Okay, here's the deal. The Commerce Clause is a short sentence in the US Constitution that gives Congress the power to regulate commerce between the states. But over time, it has become interpreted by the Supreme Court to become one of the most tyrannical tools for government overreach that's ever existed. To the point where in 1942, the federal government told a farmer in Ohio that he couldn't grow his own food on his own land for his own consumption. Yep, that's what we're dealing with. I'm Jake the Lawyer, and welcome back to Internet Esquire. All right, so if you're wondering how is it that the federal government can get into some of the most ridiculous aspects of our daily lives, look no further than the Commerce Clause. Now, some of you may have heard of it, and some of you may have not, but either way, it comes from Article 1, Section 8, Clause 3 of the United States Constitution, which says, Congress shall have the authority to regulate commerce with foreign nations and among the several states and with the Indian tribes. That's it. That's literally all it says. So how did we go from that clause in the Constitution to a point where the US government could tell an Ohio farmer that he couldn't grow his own food? And what does this mean for us today? Well, thank God, I thought you'd never ask. Let's get into it. The reason why the Constitution even has a Commerce Clause to begin with is because under America 1.0, the national economy wasn't really functioning like a national economy. And by America 1.0, I mean the Articles of Confederation, which were the national governing documents of the country from 1781 to 1789. Well, it's not really surprising to us today that if you have a loose confederation of effectively semi-independent nation states who can print their own money and whose participation in the national government itself is effectively voluntary, you're not really going to get a strong, unified national economy, are you? And like any country, the economics of America are the bloodstream of the country. So when the Constitution was written, it introduced the Commerce Clause as a way to fix this problem and gave Congress the power to regulate commerce between the states. Now, a quick side tangent for all you legal sticklers out there. In this video, I'm not going to be talking at all about the dormant Commerce Clause, okay? I'm not going to discuss that. That would be a whole nother video, and perhaps it will be another video. But for now, we're just going to stick to the one that's written down and the way that that's been interpreted over time, okay? So know that I know that it's a thing, but we're not going to talk about it in this video. Okay, moving on. Okay, so Congress can regulate commercial trade as it passes between the states, otherwise known as interstate commerce, which is great. You know, I think we can all agree on that. I mean, how useful. Woo-hoo. That totally makes sense. But the point of the Commerce Clause was not to allow Congress to regulate everything under the sun. The point was to stop individual states from competing against one another in a way that either undermined another state, forced a decision onto another state, or undermined the national economy. And as we came out the gate with the Constitution being effective from 1789 onward, everything seemed to be working that way. It worked fine, and we got our first case telling us a little bit more about what the Commerce Clause means in 1824 with the case of Gibbons versus Ogden. Now, way back in 1798, the state of New York gave founding father Robert Livingston and his business partners a monopoly on who could run steamboats within the territorial waters of the state of New York. Ah, yes, the great business of the exclusive rights of steamboating. Here you are, Mr. Livingston. Thank you for helping the drafters of the Declaration of Independence. From this point forward, only you can have steamboats on our waters. Anyway, one fellow named Ogden, who also happened to be the former governor of the state of New Jersey, was operating under this license of monopoly that Livingston had, and in 1815, he went into business with a man named Gibbons. And for a while, everything was great. It was like Steamboat Willie out there. Steamboat Willie and his friends just out there having fun, making money hand over fist with their little license to the steamboat monopoly. That is until Ogden woke up one day to find that Gibbons was also operating a steamboat under a federal coastal license to bring people and goods from New Jersey into New York, thereby accessing New York territorial waters without the license and without Ogden. No, Gibbons, you bastard! How could you do this to me? Well, as you might expect, Ogden sued, asking the courts of the state of New York to ban Gibbons from accessing the waters of that state. But Gibbons, like the savvy Southern planter and businessman that he was, hired famous lawyer Daniel Webster, who was also an American statesman who was a representative in the U.S. House of Representatives, a senator in the U.S. Senate, Secretary of State to one of the presidents, and also had argued like over 200 cases before the Supreme Court. Anyway, I don't know. I don't know why it's important to give a backstory on all of these guys. I just think it's wild, especially in these early American law cases. It seems like everybody is somebody when we're talking about the establishment of these early rules. Okay, well, this goes all the way to the Supreme Court, and they end up finding that the word commerce, and among the several states, means a lot more than just buying and selling between the states. They find that it also includes the navigation and the transport of those things from one state to another. And because steamboats were traveling interstate, in this case between New Jersey and New York, they found this to be part of interstate commerce and therefore something that Congress had authority over. So effectively, the early ruling established this. New York, hey, you guys can do whatever you want in your territorial waters. That's fine. We don't care about any of that. But the moment that one of your boats starts going between your waters and the waters of another state, that becomes interstate commerce, and Congress now has the authority. And honestly, that makes complete sense. It's well in line with the language of the Constitution, and for a long time, court decisions that involved the Commerce Clause would simply draw new lines establishing what was considered interstate commerce and what wasn't. And there's a couple interesting examples that might seem surprising to us today. They found manufacturing and mining to not be interstate commerce, even if the products that resulted out of that manufacturing and mining eventually entered into another state. That transportation of goods was interstate commerce, but the manufacture of the goods within a particular state was not. And the same thing could be said for production. They found that production was something that happened before commerce. And they did the same thing with agriculture, something that was grown on the ground in a particular state that had not yet been brought to market into another state, was not part of interstate commerce before that moment, and therefore Congress could not control it. And local activity inside of a state was local activity. Even if later on in the process of selling that product, it eventually entered the national economy. And this perspective was affirmed once again 70 years later in 1895 in the case of United States versus E.C. Knight. Here in 1892, when the American Sugar Refining Company took control of the E.C. Knight Company, it resulted in a sugar monopoly where they now controlled over 98% of all sugar refining in America. The federal government then stepped in and tried to stop the deal, arguing that it was a monopoly in violation of the Sherman Antitrust Act, which derived its authority from the Commerce Clause. The problem with that theory, however, was that all of the sugar refining that the American Sugar Refining Company was doing was happening in the state of Pennsylvania. So in an 8-1 near unanimous decision, the Supreme Court found that while the deal between the companies did create a monopoly over a basic necessity of life, sugar, the government could not suppress the activity under the Antitrust Act and therefore the Commerce Clause, because the business of sugar refining in Pennsylvania bears no direct relation to commerce between the states. And it specifically found in its ruling that the business of refining sugar was separate and apart from the business of shipping it and selling it across state lines. And since the monopoly at issue was over manufacturing and not the actual interstate trade itself, Congress could not step in and control that activity through the Antitrust Act. And then, like so many things in 20th century America, the Great Depression and the New Deal pretty much changed everything. A change which I think we are still debating whether or not it was for the best. But anyways, here's what happened. The Gilded Age Court of the late 19th century, which was responsible for the Knight decision and for keeping the Commerce Clause within its technical definition and separating things like manufacturing from actual trade between the states, had largely gone by the wayside by the 1930s. The introduction of the income tax, World War I, and the populist movement to make the rich pay their fair share had largely come of age, and the sentiment of workers' rights had been well established. Now, if you're interested in this topic specifically, I did an entire video called How Tax the Rich Turned into Taxes for Everyone, which you can see with the link in the description. Anyway, as a result of this populist fervor at the height of the Great Depression, Congress passed the National Labor Relations Act in 1935. It was designed to guarantee the right of private sector workers to organize their own trade unions, and you're never gonna guess where Congress cited the Constitution for its authority. You're never gonna guess. The Commerce Clause. They did it. again? Well, as a result of the National Labor Relations Act, the law established the National Labor Relations Board, whose job it was to prosecute violations of labor law and oversee the process by which unionization in the private sector could take place. So when the Jones and Laughlin Steel Corporation fired 10 of its employees at one of its plants as a result of them attempting to unionize, the NLRB stepped in and ordered the workers to be rehired and given back pay. But like any good steel corporation, J&L Steel refused, arguing that the order was a violation of the Constitution and that the NLRB had no authority to make that order because it did not involve interstate commerce. And in a split 5-4 decision, the Supreme Court found this. Although activities may be intrastate in character when separately considered, meaning within only one state, if they have such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions, Congress has the power to exercise that control. So anything with a close or substantial relationship to interstate commerce now also becomes subject to the authority of Congress under the Commerce Clause. Do you see the difference now? It didn't actually have to be the activity of commerce itself. Now, so long as it affected that activity, Congress could also control it. And the 5-4 decision is sort of classic Supreme Court shift in interpretation stuff here. 9 times out of 10, there is some new act that brings up an old question, and then the court has to take that question up and make a new decision in order to give further guidance on the question of the law. And anytime there is a shift in the wind on this type of decision-making within the Supreme Court, they typically start with like a 5-4 opinion or a 6-3 opinion, something that's very close. And the majority comes out of left field with some new rationale for how the law should now be interpreted going forward. And more often than not, these rulings have the feeling of, well, we've never really encountered this before, so we're going to lean a bit more into how it feels rather than how the law is actually written. And this happens so often in the law that we actually have a term for it. We talk about it in terms of whether it is looking at the spirit of the law versus the letter of the law. And that's not to say that looking at the spirit of the law and letting that control in certain instances is inherently wrong or something like that. Even though I'm more of a letter person myself, there are typically good arguments on both sides. And as a result, over the course of history, both ends of the political spectrum have had Supreme Court decisions that sort of fell in their favor. And whether the spirit or the letter of the law is predominant typically depends on the particular circumstances and the particular time in which a case is reviewed. So anyway, that's my little contextual rant here, and as we can see in this case, the Supreme Court is leaning more into the spirit of how they thought the Commerce Clause should be interpreted. And we know this because their ruling also says this. Long ago, we stated the reason for labor organizations. We said that they were organized out of the necessities of the situation, that a single employee was helpless in dealing with an employer, that he was dependent ordinarily on his daily wage for the maintenance of himself and family, that if the employer refused to pay him the wages he thought fair, he was nevertheless unable to leave the employ and resist arbitrary and unfair treatment. Which, sort of leaves out entirely the idea of personal autonomy and the freedom of assembly and association to leave one employer and go to another and to, maybe crazy idea, find better circumstances working for a different person. I think this is the classic view of looking at, the poors as no better than helpless dogs who just can't make decisions on their own. And, these poor people, we have to make decisions for them. Which, is a mentality that is entirely bigoted and patronizing in and of itself. But hey, at least you're trying to help. Now, admittedly, labor relations in the late 1930s were a lot different than they are today, and it was partially as a result of union advancement from that time forward, which is why we have better working conditions today, but still. It's not like the Supreme Court had to do this. Like, this could have come about through other means. Okay, so that's where the shift in approach to the Commerce Clause began with the New Deal and during the Great Depression. And then in 1941, the case of United States versus Darby took it even further. This case involved the Fair Labor Standards Act, which again took its congressional authority out of the Commerce Clause. And this act was responsible to set the federal minimum wage and several other working standards of the day. But it could only do this so long as the company produced something that was part of interstate commerce. A lumber company that operated entirely in Georgia was charged with violating the act in 1941 for basically paying workers below the federal minimum wage, which up until 2 years before didn't exist at all. And of course, the owner sued, arguing that the federal minimum wage did not apply to him because he operated his business entirely within a single state. And in a unanimous decision, the court found that while the operations took place entirely in Georgia, because the lumber produced eventually entered other states, it could now be controlled under the Commerce Clause. It was as if the NLRB versus Jones case was sort of a warm-up, and now United States versus Darby was the true session. And they went even further. Not only did they make a unanimous decision, they also overruled previous findings which had found and made distinctions between things like manufacturing and production as not being a part of interstate commerce. Okay, so I think you can see where this is going. We have this super simple phrase, which wasn't intended to tell lumber companies how much money they needed to pay their employees. It was intended to ensure that states did not fight with each other economically. And now in Darby, 150 years later, it was being used by politicians in Washington, D.C. who had probably never worked at a lumber mill or in a steel plant to tell the owners of those businesses that they couldn't get rid of certain employees and how much they had to pay those employees. So you want to talk about spirit versus letter of the law? I'm still scratching my head trying to understand how, even if that was in the spirit of the Commerce Clause, how it could have been taken that far. Well, I'll tell you why. It's because the laws written on top of that Commerce Clause were then interpreted by a bunch of people in robes who had also never worked at a lumber mill or a steel plant. And that's not that we should be preventing companies from actively trying to create the best possible working conditions for their employees. That's absolutely what we should be doing. But don't you think that should be happening at the state level? Why is the federal government involved in that in any way? That is a state law issue, and if you look at the Constitution, we have something for that. It's called the 10th Amendment. The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Meaning, in the Constitution, any power not specifically written down and given to the federal government, nor specifically written down and prevented from being given to the states, belong to the states and their people. And because the Supreme Court was making such an outrageous interpretation of the Commerce Clause in the case of Darby, they of course had to address this. And here's what they had to say about our beloved 10th Amendment. Our conclusion is unaffected by the 10th Amendment. The amendment states but a truism, that all is retained which has not been surrendered. Nothing makes my biscuits burn more than that. The entitlement of a Supreme Court judge to sit there and go, well, the 10th Amendment is but a truism. Of course, we don't really need that. No, you know what's better? Instead, we'll take the Commerce Clause and make it a de facto surrender of all states' rights that have ever existed, because at some point they might enter commerce somewhere. That's better. But if you think it couldn't get possibly any worse from here, boy, have I got a story for you. Do you remember the farmer? In 1938, Congress passed the Agricultural Adjustment Act as an alternative and replacement for farm subsidy policy that had taken place just a few years earlier. And why would they do this, you might be asking? Because in 1933, the Agricultural Adjustment Act of that year was found to be unconstitutional. You see, for the 1933 Act, Congress utilized their tax and spend authority, also under Article 1, Section 8, as the justification to effectively control agriculture at the federal level, an industry understood at the time to be exclusively controlled by the states. So when Congress used a processing tax as part of the act to pay farmers to reduce certain crop outputs, the act was found to be unconstitutional, because Congress can't use their delegated authorities to accomplish an otherwise unconstitutional act outside of their delegated authority. So if the ability to control agriculture at the federal level was found to be unconstitutional under the 1933 Act because Congress used their tax and spend power, what do you think they did in 1938? Well, they saw NLRB versus J&L Steel Company in 1937, and they said, hey, maybe we do have the authority to control agriculture at the federal level. So instead of looking at the situation and saying, you know what, maybe we just shouldn't do that. They looked at the situation and said, let's try it again, but this time with the Commerce Clause. So it is as a result of the 1938 Act that the case of Wickard versus Filburn enters the Supreme Court lexicon in 1942. With their trademark new and improved recipe for controlling food at the federal level, the Department of Agriculture established limits on how much wheat a farmer could produce based on how much land they had in an effort to stabilize wheat prices nationwide. Because, farmers and markets are incapable of stabilizing markets on their own. We need the Department of Agriculture to do it. So here's what happened. An Ohio farmer named Roscoe Filburn grew his own wheat on his own land to be used for his own consumption on his own farm, for both himself, his family, and his animals. And the Department of Agriculture ordered him to pay a fine for growing more than he was allowed. So like any self-respecting American who wasn't born inside of a drawer inside of some government bureau somewhere, Roscoe sued the federal government. He argued, rationally so, that the wheat that he grew was not subject to the new laws because it, first of all, wasn't even for sale, therefore it wasn't even within the flow of commerce, and even if it wasn't leaving the state of Ohio, therefore it wasn't subject to interstate commerce, and therefore not subject to the Agricultural Adjustment Act of 1938, trademark new and improved recipe. So what did the Supreme Court do? They came up with one of the worst ideas they've ever had, and it's this idea called aggregation. The aggregate principle of interstate commerce effectively says this, and they say this in the ruling, that Filburn's own contribution to the demand of wheat may be trivial by itself. It is not enough to remove him from the scope of federal regulation, where, as here, his contribution, taken together with that of many others similarly situated, is far from trivial. It can hardly be denied that a factor of such volume and variability as home-consumed wheat would have a substantial influence on price and market conditions, and it supplies a need of the man who grew it in which would otherwise be reflected by the purchases in the open market. Homegrown wheat, in this sense, competes with wheat in commerce. Thus, even if someone's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. So now, under this principle, if anything in any way affects interstate commerce, it's now under the control and authority of US Congress. And to me, this is insane. I'm just gonna say it. How could we go from a simple clause like this in the Constitution to then telling a man he can't grow his own food? And the only rationale I could come up with becomes a little bit more clear when you actually abstract this case away from the law itself. They did this because the entire New Deal strategy under FDR was to take over industry that had previously been left to the states and to the people. That was the entire strategy. They said, we need to pull ourselves out of the Depression. Everybody together now, we're gonna do this, and while we do it, we're just gonna take over everything. It has nothing more to do than the fact that the cold, hard reality of ruling in favor of Filburn, in the case of Wickard versus Filburn, would have meant that the Agricultural Adjustment Act would be unconstitutional. It would have limited the Commerce Clause, which would have left agriculture under the authority of the states, and that would have been exactly the opposite of what the federal government was trying to do during the New Deal and the Great Depression. We just couldn't have states controlling their own agriculture. It's not like we did that for the first 160 years of the country and it worked out just fine for everybody. No, we can't have that anymore. Sorry, this one really gets me. You know, some people get fired up by the Second Amendment. Some people get fired up by abortion. I get fired up by the Commerce Clause, evidently. It's because this goes way beyond, hey, let's all just work together and pull ourselves out of the Depression. And I think that's what makes this so frustrating, is because we know that there's something inherently wrong with the court making a decision like this, but we can't quite articulate it. We know it goes beyond just bad government policy. It goes to something deeper, the natural rights of man. This violates the social contract where governments are instituted by men to protect natural rights by placing government policy above those rights. Telling somebody that they cannot grow their own food for their own consumption on their own land violates the right to life, which is one of the most sacred natural rights we have. Life, liberty, property. There they are. The entire reason under natural rights theory why governments exist is to preserve natural rights and provide for the common welfare. That's it. And we're just clearly violating that because other people might also grow their own food? That's the justification? Well, what if everyone grew their own wheat? Oh my God, what would happen then? Okay, rant over. Fortunately, not all is lost. Well, the Filburn decision did usher in a new era of government overreach, the likes of which had never been seen before across the face of Western society. A little over 50 years later, the Supreme Court did, under a new era and in a new age, begin to put some outside limitations on what this interpretation of the Commerce Clause meant going forward. The first step came in 1995, when Congress tried to take any local problem and, by amplifying its downstream effects, turn it into an interstate commerce problem. That's right, I'm not kidding. If you thought they wouldn't try anything worse after Filburn, have I got a deal for you. They in fact did, proving once again the theory that remains across all the videos on this channel, that governments will do, or try to do, anything they have been given the power to do, even if it wasn't intended. If you learn one thing, just one thing from watching this channel, please, for the love of Jesus the Redeemer, let it be that. Please. So here's the story. In 1990, Congress passed the Gun-Free School Zones Act, which prohibited any unauthorized individual from knowingly possessing a firearm, well, within a school zone. Now, if you aren't super familiar with how this works, there's already a ton of state law around this issue, and depending on which state you're in, those are the laws that are going to apply. And it's not that anybody doesn't want safe schools, of course, we all want that. But this is where people always get confused. They hear something like this, oh, the Gun-Free School Zones Act of 1990? That sounds wonderful. Why are you against that? Because there's already state laws for this. And it sounds like if you don't agree with them, well, then you just kind of hate children and safety and America itself. But guess what? Oh, surprise, it had nothing to do with any of that. Now, by what authority do you think they pointed to in the Constitution to justify the Gun-Free School Zones Act? The Commerce Clause, yes, of course. And then came the case of United States versus Lopez in 1995. In 1992, an 18-year-old high school senior who was attending a San Antonio high school brought a .38 caliber revolver to the school, not for nefarious or horrid reasons, but with the intention to sell it to another student. Now, granted, is that a good idea? No. But is he an 18-year-old? Yes. It doesn't make it a good idea, but also 18-year-olds, they were the same 18-year-olds then as they are today. So when he was indicted for a criminal violation under the act, he moved to dismiss the indictment on the grounds that the act was unconstitutional and exceeded congressional power under the Commerce Clause. The government's primary argument for why the School Zones Act was constitutional was based on this logic. Possession of a firearm in a school would be seen as dangerous. This would in turn inhibit learning, which would in turn weaken the national economy since education is critical to the nation's economic health, which would therefore affect interstate commerce. Don't you see it? But you know what? Given what they had seen from Filburn's case in 1942, it's not surprising that they made this argument. Why wouldn't they? And here's the real shocker. The Supreme Court only rejected this argument and ruled in favor of the kid in a split 5-4 decision, meaning that there was one person in a fancy robe in Washington, D.C., who effectively decided whether or not the Commerce Clause could expand past commerce in every conceivable way and effectively touch every aspect of our lives. Because if that logic, which 4 of the Supreme Court justices found to be legitimate, was the majority, what would that have meant for the future? I mean, effectively anything. Anything is now commerce. You going number 2 in the woods is now commerce. Well, it's time away from whatever it is you were doing. Think about if everybody else was also going number 2 in the woods. Think about what that would do to the American economy. I mean, we just couldn't have that. No. Commerce Clause. Congress, make a rule. I'm joking, but that's like the Babylon Bee headline version of what they were actually trying to do. Even if you're not like a 2A person, hopefully you can appreciate and understand what hung in the balance as a result of this ruling. I mean, if it would have gone the other way, then effectively Congress now has the authority to touch everything and anything in our daily lives. But thankfully, as a result of the Lopez case, we can begin to see this shift in the wind. And as they say in sailing, a shift in the wind foretells a change in the weather. Later cases like United States versus Morrison and the National Federation of Independent Businesses versus Sibelius have come along after Lopez in 1995 and reinforced the lines that were drawn around the authority of the Commerce Clause in that case. But even in those cases, at least with respect to the portions of them that dealt with the Commerce Clause, you still got these Supreme Court split 5-4 decisions. In United States versus Morrison, the case centered around whether victims of gender-motivated crimes could sue their attackers in federal court. And NFIB versus Sibelius was related to Obamacare. And to be fair, in that case, we did get one additional win, but it was a very small one with respect to the Commerce Clause. In Sibelius, the court found that Congress could not compel commerce by an everyday person and then use the Commerce Clause to control that person's actions. That was a win we got out of the Obamacare cases, but, that's like world's smallest golf clap, Woo! Great, we can't force American citizens to buy things and then control aspects of their daily lives after we forced them to buy those things. So where does that leave us today? I think it's clear that the cases that began with Lopez and now that we're seeing today are thankfully putting limits around the Commerce Clause. That is a win for the everyday American. Because let's be serious for a second. We can't really honestly be living in a world where the Constitution says Congress shall have the power to regulate commerce among the several states, and that effectively therefore means states have almost no authority to regulate or do anything on their own. We can't be living in that world and gutting the totality of states' rights. Look, we all know where that comes from. It comes from the 14th Amendment and it comes from slavery. That was fair, and we had a whole lot of time to get up to where we are now, and now we are here and it's the 21st century, and the stuff that you're talking about was happening 150 and almost 200 years ago at this point. So let's just focus on how the broad interpretations of these let's get rid of states' rights ideas have actually affected regular American life in today's world. Because if you're like most Americans, you're probably getting pretty sick of it at this point. But anyway, that's the video. That's the Commerce Clause. If you liked this more ranty style, let me know in the comments if you did. Also, let me know in there if you have other video ideas you'd like to see me go over. I love to jump in with everybody and chat with them. Thank you for everybody who's been in there with me, giving ideas and helping make this channel better. And thank you to all the subscribers. If you've seen more than one of these videos, consider it. We're passing 55,000 subs now, which is crazy. Anyway, that's all I have to say. I hope you have a wonderful day, and I'll see you on the next one. Whew. My voice is shot after that. Just yelling. Just some guy yelling in his office.